Welcome to Sakshi TV's special immigration show with attorney Bhanu Babu Illindra from BBI Law Group. Please note that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Ms. Prashanthi Reddy in English, and on Friday at 6 p.m. EST with attorney Bhanu Illindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email usa@sakshi.com or call 866-725-7441. Before we begin the show, please know that the information provided on this show is not legal advice. Use of content is for general informational purposes only. Sakshi TV or its agents in the USA or our guests on this show are not responsible for use of information as legal advice. If you need specific legal advice, please contact attorneys directly. We will be also taking any general immigration questions along with today's topic. Hello Bhanu Garu, welcome to the show. Could you please provide us information on your law offices, practice areas and your experience?
Thank you, Tony, for welcoming me on the show again. And my name is Bhanu Illindra. I'm an immigration attorney. My firm name is BBI Law Group PC. We exclusively practice in immigration laws. Our office is located in Herndon, Virginia, which is Washington, D.C. suburbs. Our firm address is 950 Herndon Parkway, Suite 355, Herndon, Virginia, 20170. Our website is www.bbilawgroup.com. And they can reach me on 703-496-7722 or my email bhanu@bbilawgroup.com. We are very happy to help in immigration matters. We represent in all types of immigration matters, from employment-based immigration to family-based immigration, EB-5 investor visas, F-1 visa student issues, all types of immigration matters. That's what we do, Torani.
Yes, Bhanu Garu, thank you so much for the information. Also, before we get into the topic and updates, I'd like to wish you, I hope you had a very happy and a safe Diwali, and would also give you a belated wish from the team of Sakshi. Happy Diwali, sir.
Thank you. Thank you, Tony. Wish you the same. Happy Diwali. And,
thank you so much.
Yes, it has been very good Diwali this year. Yeah.
Right. So, getting on to the topic, before we actually start with the questions, sir, do we have any immigration updates for this week?
Not many. I mean, as I said, everything is very, very calm now with the immigration world, especially with US immigration. Only update is that we all know that from November 8th onwards, people traveling from India do not need national interest waiver, national interest exception, basically, to travel to the US. They're lifting the travel ban from the people who are traveling from India and other 33 countries because of the COVID-19 pandemic. Only requirement is that they provide the proof that they're fully vaccinated, and also they have a negative COVID test that has been taken within 72 hours of the departure to the United States. Good thing is that previously we were worried whether people who have been vaccinated with Covaxin will be able to travel to the US or not. Good thing is that WHO has actually approved the emergency authorization, has given the emergency authorization to use the Covaxin as a COVID-19 vaccine. Therefore, people who are fully vaccinated either with Covishield or with Covaxin now should be able to travel to the US. They have to provide a proper documentation to the airlines and also to the officers at the port of entry or at the consulates if they're applying for a visa that they're fully vaccinated. As long as they document that, now people from India should be able to travel without any problem to the US. Same thing with the Indian government also. Now they lifted all the restrictions towards the traveling for the tourists to India. Now everybody should be able to apply for visas and they should be able to travel to India as well. So it's a good thing.
Right. So Bhanu Garu, I don't know if it's a good news for anybody else, but for me, it definitely is that Covaxin is also approved by World Health Organization, and I'm sure a lot of people who are vaccinated with Covaxin like me would feel free to travel now, because there was definitely a big stir around this one particular vaccine, and that Covishield is more accepted. Also, you stated just a while ago that there's not much of disturbance in the US consulate. Is that a good news? I mean, is it nice that there's not much of disturbance or too many immigration problems right now? Are we going towards a good direction?
I mean, you can say that, but at the same time, we know that if it comes to non-immigrants who are planning to come to US work on here temporarily, or who coming for visitor visa to the US, I think it's a very good news right now because there are not too many restrictions that are happening with the traveling, you know. However, if it comes to green cards, we all know that the priority dates have moved backwards, especially in the employment-based immigration. For them, it's a little bit stress period right now because they have to wait until the dates become current again for them, their 485s to be adjudicated, who already filed 485s and waiting in a queue to get the green card, or people who wants to file 485 also, they have to wait until the dates become current again. So that's a little bit back. I mean, that's a little bit back step for them, but hopefully the dates will start moving forward again. As we said, as we anticipate, the timelines will be from February, March of 2022, and hopefully that will happen.
Right. So, Mr. Bhanu, we have a caller on hold, Mr. Kumar from Atlanta. Thank you for calling, Mr. Kumar. You may ask Mr. Bhanu your question directly.
Hi. Hi. Thank you, Tony, for giving me the opportunity from Sakshi TV. Hi, sir. Bhanu, sir. I have a question related to CSPA, Child Status Protection Act for immigration. So my son is right now 14 years of age. We applied our filed 485 October 25th in ED3. The date was current in October, September bulletin, but we filed in October.
Sir, your voice is not clear, sir, for me.
Yeah, Mr. Kumar,
yeah,
can you please speak up?
Hello, can you hear me now? Much better?
Yeah, it's better right now. It was echoing before. Yeah, it was better right now. It is better right now. Yeah.
Okay. So this is related to Child Status Protection Act.
Yes, sir.
Okay.
Tell the fact first.
Yeah. We applied our 485 October 25th. That is for 140 and 485 both applied at a time. 140 is in premium. And in November bulletin, the dates have retrogressed. And still my son is protected.
How old is your son?
Right now he is 14 years old.
Yeah, very likely. I mean, when you filed your I-140 and 485, you filed your 485 based upon the final action dates or based upon the filing dates? Hello? I think we lost him. Did we?
Final action date, sir.
Ms. Thorni?
Kumar is on the line. Hi, Kumar, can you hear us?
Yeah, I can hear you.
Yeah. So, Bhanu Garu, please ask your question.
Did you file your 485 based upon the final action dates or based upon the filing dates in October?
Final action date, sir.
Okay, if that is the case, you have nothing to worry about. As long as your son remains unmarried, even if he surpasses 21 years of age, and at the time if his 485 is still pending, he may be eligible to get a green card. He may be protected under CSPA, Child Status Protection Act. Okay, and
Yeah.
it's a very complex statute, and it's very difficult for me to explain to you the entire statute, how the math is calculated and everything over here. But in general, with the facts, what you have told me is that your son may be protected under CSPA, and the CSPA age will be calculated beyond 21 years of age till the date he gets a green card and everything, as long as he remains unmarried. If he's above 21 years of age, if he gets married, then he will lose the status of child, and he won't be eligible for the CSPA benefit at that time. Protection, I'm going to say CSPA protection at that time. So he's okay. What we will do is, Mr. Kumar, me and Thorani will discuss on this if possible. I will do one exclusive show under the Child Status Protection Act and explain the calculations, how USCIS explained how one can utilize, how one may be protected under CSPA and everything. But in general, right now, with the question what you asked, you have nothing to worry about your son as long as he remains unmarried.
Right. I hope that answered your question, Kumar. Thank you for calling. So, Bhanu Garu, moving on to our immigration updates and other employment-based green card questions. Could you explain to us what an I-40 is and how can one file it?
Okay. I-140 is a form. It's a USCIS form, mainly filed by an employer on behalf of their employee in a regular categories other than EB1 category, EB1A category, where one can self-petition, or if somebody is filing under the national interest waiver, also one can self-petition. But the form I-140 is an immigrant visa petition for alien worker. That means it is the form you need to submit to the USCIS along with the all other supporting documentation to seek a green card, to seek a permanent residence in the United States on behalf of an individual who is an employee or will be an employee for the particular company. That's the form I-140 is. I-140 has to be approved in order for somebody to be eligible to file for adjustment of status in the US or to seek a immigrant visa, that means green permanent resident visa abroad at the consulate. So it is the one which decides when one is eligible for the green card or not, is the form I-140 petition.
Right. So I think there's a common misconception that I-140 is also kind of the green card. So, which is what we found on one of the FAQs, which is why I wanted to start off with this question. So, Bhanu Garu, is the perm labor certification necessary for all employment-based green cards, Andy?
No, not for all employment-based green cards. It's necessary for the EB2 preference category and EB3 preference category. And also in EB2 preference category, if you're seeking I-140 petition through national interest waiver, then you do not have to file labor certification. Perm labor certification to file I-140. Only for all other types of advanced degree category, on all types, on all other EB3 categories like professional, skilled worker, and other worker categories. All those four categories are the ones which requires individual to go through the perm labor certification process prior to the filing of I-140 petition.
Right. So Mr. Bhanu, Kumar from Atlanta has gotten back on the call again. So we're putting him right through. Mr. Kumar, you can talk to Mr. Bhanu now.
Thank you, Torni, giving me the opportunity. So,
Sure.
Bhanu,
Mr. Kumar, please, if you're in the speakerphone, please come back to the normal phone because I'm getting echo from your end.
Yeah, echo is coming from the in between. I'm not talking on the speaker, sir. Okay. The 140 is approved after retrogression. November 2nd, my 140 is approved, sir. Still, yes, we applied 140 and 485 together. 140 is approved after retrogression. In November 3rd, my 140 is approved. Still, CSPA age is locked, right? That's what my questions are. Thank you.
No, the CSPA works either for I-140 or 485. It's just not only for I-140, okay? Because you file I-140 and 485 together, when final action dates are current, the processing time for I-485 will be calculated for your kid to calculate the CSPA age upon him crossing 21 years. Okay?
Okay. 140 need not to be approved before the retrogression happens, right, sir?
It does not matter. It does not matter when the I-140 is approved.
Thank you, sir. Thank you very much.
Right. Sure. Thank you for calling, Mr. Kumar. So, Bhanu Garu, moving to our next question. What happens when, let's say someone has applied for a green card and for their relative's visa while being a green card holder and then becomes a US citizen? Will that affect his or her family members, his relatives, I mean?
The relatives means you're talking about if they're immediate relatives, like if you're filing the green card, you being a permanent resident holder, you being a permanent resident in the United States, if you sponsor a green card to your immediate relative, like your spouse or your children who are unmarried and below 21 years of age, then once you become a citizen from the permanent residency status, their petition, which is pending for the processing of them getting the green card with the USCIS or at the consulate, will be automatically converted into the immediate relative petition of the US citizen spouse. Okay, so that is actually, it will bounce upwards from the F2A category to immediate relative category. Basically, immediate relative category does not have any limitation on how many visas can be issued in a year, whereas you being a spouse or a child of a US permanent resident holder, then you're limited to how many visas you can get in a year. But being an immediate relative of the US citizen, you don't have that limitation. As many as you can, as many people as they can apply for their immediate relatives of the US citizen spouse, basically. So once the individual naturalizes and becomes a US citizen, their petition as a permanent resident spouse will be converted into a spouse of a US citizen or a child of a US citizen if the petition is for the child. Hope I'm explaining it properly. Hope you're understanding what I'm saying.
Oh, yes, of course.
It's actually upgraded. It's upgraded from permanent resident spouse to the US citizen spouse, basically.
Right. So could you also explain to us and our viewers what an RFE is? This is a most commonly asked FAQ, and what are the chances of being approved after an RFE?
I will answer the later part first, and
Right.
then I'll go with what is an RFE is. Okay. The chance of getting an approval with the RFE after the RFE response is equally good as much as the chance of getting an approval of a petition or an application without an RFE. Okay. RFE is, now I'll talk what is an RFE is. Okay. RFE is request for further evidence. What does it mean is that the USCIS, when they're adjudicating somebody's application or a petition for which they're seeking an immigration benefit or a non-immigration benefit into the United States, the USCIS sometimes may feel they need additional information in order to make a decision properly, whether it's an approval or a denial. To make a decision properly, they need some more information. They have all the basic information, but something important part of that evidence is missing for them to make a decision, whether it's a favorable or unfavorable decision. And in that process, they usually issue a notice called request for further evidence, and when they issue the request for further evidence, that means the US is actually adjudicating your case and they're asking for additional information from you. And if you can provide that additional information, the case may result in your favor. If you cannot provide that additional information, then you need to make a justification to the USCIS why the evidence already submitted is enough and they don't need any additional information to adjudicate the case properly. So 90% of the time, not 90% of the times, I don't want to give any percentage or number or anything like that. Most of the RFEs are actually good because they're asking you if any information is missing to provide that information so that they can make a decision positively. That means they're giving an opportunity for you to rectify anything in filing you missed. Like if you missed attaching some document, they're giving you an opportunity to provide the document so that they can make a favorable decision for your case.
Right.
So in that way, request for further evidence is a very good thing. And as I said in the beginning, approval chances, it all depends upon what documents we provide. For us, we never had any problem in our office responding to the request for further evidence without any issue. I mean, it's very rare we see adverse decisions in our office for the immigration benefits.
Right. So, Mr. Bhanu, we have another caller on the hold, Mr. Santosh from Chicago. Thank you for calling. Mr. Santosh, you may ask Mr. Bhanu your question directly.
Hi, I have two questions. Can you hear me?
Yeah, we can hear you. Please go on.
I can.
Okay, thank you. Hey, Bhanu, two questions I have actually. So today I got 765 approved, like not my wife got approved today, but I-131 still shows like it's received. So do I get any combo card or just only EAD card? That is one question. And another one is like how safe to travel with the AP, traveling outside the United States? Like, is there going to stop anything for me to come into the United States with AP? Yeah, those are two questions.
Yeah, I mean, if your EAD is approved separately and if your advance parole is not approved, then it's very likely that you may get a separate EAD card and separate advance parole notice. It won't be a combo card. If they approve both together, then it's very likely they will issue a combo card. But what you are telling me, it's very unlikely that you may get a combo card. You get an EAD separately and the advance parole separately. Okay? And traveling on advance parole is as safe as traveling on a H-1B visa or L-1 visa or any other non-immigrant visa. You know, the requirement for advance parole is that your 485 is still pending and will remain pending in the USCIS, and you do not have any other violations or any other bars to be admitted into the United States. Whenever you're going outside the country and you're coming back to the US, you are seeking a fresh admission. Okay, and if you're coming on advance parole, you're actually seeking admission into this country. But however, they're going to parole you, and that's why you're coming on a parole. The parole is actually given for you for that purpose only, for the traveling purposes. So you should not have any problem traveling to it unless you have any other bar to be admitted to the United States, as I told you just a minute ago. You know, I repeated the same.
Right. Right. So thank you for calling, Mr. Santosh. I hope that answered your question. So, Bhanu Garu, in relation to what we were talking before the caller came along, you told us that RFE is not really that much of a problem. But there is also a conception that we found a lot of people have this assumption. We want you to break the myth on it or tell us what is right or wrong about this, that whenever the USCIS sends, tells you that there's an RFE, they request you for further evidence and you provide them with that evidence, right? So which means there's going to be added amount of stack of documents or probably other documentation process or other files or folders that are required, which means it's going to stack up for a while. Does that automatically increase the processing time for that particular petitioner, or is that a misconception?
It may. No, it's not a misconception. It's possible that sometimes the timeline of processing time for that particular application or petition may increase because they have to review or they have to wait until they receive the documents from you for the request for further evidence. You know, when request for further evidence is issued, usually you will be given 84 days to respond to that, and that 84 days is an added time. If you did not submit the documents immediately, and if you submit the 84 days, they have that 84 days time. And also the guidelines of the USA says that once they receive the documents for the RFE, they may take up to 60 days to adjudicate that case. Okay, so it is a possibility that the timeline may increase, but as I said, that should not be your concern for the issuance of an RFE and responding to an RFE. Okay, sometimes we have seen people who respond to the RFE getting an approvals in 2 days, 3 days also. So it is not that, but yes, there is absolutely a possibility that sometimes the processing times of the application or a petition may increase or may a little bit further delayed than it is usually approved.
Right. So while we've established that rightfully so, is there anything that the petitioner can do on their own from their side to reduce their chances of an RFE?
Yes, absolutely. I mean, they have to prepare properly the petition which they're filing on behalf of their employee, right? Make sure that the documentation is properly reviewed, properly prepared. Take a help of an attorney like us. I'm not saying that employers are not capable of filing themselves, but it's not a good practice,
Right.
Because the attorneys will provide that legal expertise, that knowledge, which is very intrinsic and which requires in-depth knowledge of the regulations or a statute in which they're filing. On the face of the application or a petition, it may look very simple, but there are few very small information which we provide shall determine sometimes the outcome of the petition, or the decision by the USA. So it's important that you take a proper assistance from the attorneys and prepare the case properly. Make sure that you review all the information prior to the submission of the petition, and ensure that all the information which is required by law is submitted to the USS. Not providing unnecessary information or not providing at all any information that is required is bad. Both of them are bad. You have to provide information that is appropriately required for getting an approval. We have seen sometimes in H-1B situations and employers, they provide thousands of documents which are totally not at all required by regulations, or unnecessarily cast a doubt about the nature of the business which they are involved in. So it's important that take help of an attorney and prepare the cases accordingly and submit them. Whatever it is, even if you're filing by yourself as an employer, make sure that you do proper diligence on the information what you're submitting is actually meeting the requirements for filing for the approval of that I-140 petition or any other immigrant petition or a non-immigrant petition which you're filing on behalf of your employees.
Right. So with that, Bhanu Garu, we come towards the end of the show. It was, like always, it's a privilege hosting you. Thank you for being on the show.
Same here, Tori. Thank you. And once again, I wish you a very happy Diwali, and I think tomorrow is Bhai Dooj. Everyone have a wonderful day, and, and thank you very much. Thank you very much.
Thank you so much, sir. We wish you a very happy Diwali too. Thank you, sir.
Yes, same here. Thank you.
You're watching Sakshi TV Live with me, Torini Makana. Thank you.